Attend the card, please. Honorable Supreme Court of the State of New Mexico.
Good afternoon. You may be seated. Thank you very much. Good afternoon. We're on the record of S-1-SC-40434 Burns versus Presbyterian Healthcare. Petitioner, you may enter your appearance and begin. You have 30 minutes.
Yeah, just may it please the court, James Johnson here on behalf of the petitioner, Seth Burns, and with me.
Good afternoon.
May it please the court. Very overarching purpose of our system of civil justice is to adjudicate matters on their merits. That overarching principle concept must be balanced. The need to have orderly and efficient adjudication of cases. However, the overarching purpose remains the same. Therefore, it is unsurprising that when a sanction, a discovery sanction, results in the dismissal of the case, this court and the Court of Appeals have insisted that certain safeguards be observed prior to dismissal without an adjudication on the merits. The issue in this case is whether a dismissal by any other name should also be analyzed as a dismissal. In this matter, the district court excluded an expert witness who, as a matter of law, petitioner needed to make a prima facie case.
Just the late affidavit was excluded, right? Not the witnesses.
That's correct.
Okay.
Justice Moore. And if I may address that briefly, in our position that there is no real distinction between exclusion of the affidavit or partial exclusion of testimony, the wholesale exclusion of testimony of a witness altogether. So I apologize, I misspoke. It was just the affidavit that was excluded.
So along those lines, do you view the district court, what the district court did as a sanction in and of itself? Because what the district court seems to think it did was simply not allow an extension of the scheduling order.
That's correct. And my response to that would be, yes, we would believe it was a sanction, and for a couple of reasons. The first is that if the district court had in fact modified the scheduling order, the result would have been that the disclosure in this case, or that the affidavit in this case, would have been timely, and so there would have been no violation of any sort of order at all in that case.
I have a question.
Yes, sir.
Did your client ever ask for an extension of the scheduling order or deadlines?
There was at the time of the hearing an extension, a motion pending to extend discovery for other expert witness depositions. So far as I can tell, there was no specific motion made to extend the deadline for disclosing additional opinions by Dr. Arnott. Petitioner did file an amended expert disclosure, which was untimely, and there's no dispute as to that.
And that's what I'm asking. And that was filed without a request for an extension. That was just done as a move on its own, right?
That's correct, Mr. Early. And I think it's important to point out in this respect that the way this was litigated below is that it was never quite clear to petitioner that the reason exclusion of this affidavit was being sought was as a result of its untimeliness, as opposed to the contradiction with Dr. Arnott, the expert witness's expert testimony, deposition testimony prior to that time. So no, there was no specific motion made to extend the deadline for disclosing Dr. Arnott. However, petitioner did disclose Dr. Arnott in accordance with the scheduling order. The issue was that disclosure was deficient, as it ultimately turned out, and petitioner does not dispute that it was deficient.
Thank you.
So is the sanction a timeliness problem, or is the sanction related to the insufficiency of the original disclosure?
I would say the two are linked, Judge Ray, and I think it's a timeliness problem insofar as the insufficient initial disclosure did not include the opinions that were later disclosed. And if I might go back to your original question about whether or not this was a sanction, I would point to Federal Rule of Civil Procedure, Rule 16, the committee commentary, the advisory committee notes as to that rule, which New Mexico's rule is in turn based on. I believe it was the 1983 amendment. The committee considered, at that point in time, as I understand, federal courts had not had any specific rule provision permitting the imposition of sanctions for violation of scheduling orders. And in the advisory committee notes, it notes cases of them just kind of relying on inherent authority to exclude witnesses. So the explicit purpose of amending the Rule 16, which mirrors current New Mexico Rule 16, was to provide a rule-based mechanism for judges to be able to exclude witnesses who were violated.
What was the sanction?
The sanction here was the striking of Dr. Arnott's affidavit.
It was a sanction, or you just didn't meet the deadline?
I'm afraid I don't understand the question.
Well, you didn't meet the deadline, right? To disclose in a medical malpractice case.
Well, so the issue, Justice Thomas, is that we did in fact disclose Dr. Arnott in a timely fashion.
Well, you didn't, but the opinion,
Was not specifically spelled out, yes. That's
right, and the affidavit filled that gap, as I understand it, correct?
Yes, Justice Thomas, I would point out that the petitioner does not necessarily concede that there's a huge gap between the opinions that were disclosed.
You wouldn't have gotten causation. You wouldn't have gotten causation without the additional affidavit. So it was pretty significant. Without that affidavit, the testimony standing on its own would not have provided sufficient facts to support causations. Right.
Petitioner does not concede that issue, Justice.
Okay.
And if I may, I just.
Well, then why is this so dire for your client?
Right, why are you worried about striking the affidavit if you had sufficient to overcome summary judgment?
Well, Justice Thompson.
Or to create a material, whatever you needed to overcome summary judgment.
Correct, Justice Thompson. We did not seek review in this court of the summary judgment ruling that the district court entered. In our view, and if I may just, as a tactical matter, this is not a court of error correction. There's plenty of case law out there addressing the proper summary judgment standard. And so whether or not the district court misapplied the summary judgment standard in this particular medical malpractice case did not seem like the kind of issue that would necessarily warrant this court's intervention. However, the summary judgment evidence that was before the court, just based on the deposition alone, and if I may note that deposition, strangely, somewhat oddly in the record, took place before this disclosure was ever made. So in some ways, I think when petitioner filled it out, it was on the assumption that the testimony that had been given was by that point known to the other side because the deposition had already taken place. And if I might just call the court's attention to volume 2 of the record at pages 444 to 45. Question by defense counsel: would you agree that when you see elevated liver function tests, that's more likely than not due to the inflammation from the actual procedure, as opposed to being from a bio? Answer: just skip ahead a little ways. Total bilirubin, direct bilirubin, alkaline phosphatase, they indicate either a bile duct injury or a bile duct leak. From other portions of Dr. Arnott's testimony, he said that petitioner did in fact have these elevated levels. So putting 2 and 2 together in a sense, he's saying petitioner had these elevated levels and that elevated levels indicate either a bile duct injury or a bile duct leak. The sole purpose of the affidavit was to make it clear that when he had said at his deposition, I don't know, I can't pinpoint the timing, the onset of this bile leak, that was tied to the actual leakage of bile from intraoperative injury of the petitioner suffered.
So let me ask a question. So you're disputing the finding that the trial court made that it was contradictory and that it was new evidence in the affidavit?
Judge Gurley, we do not, we are disputing that, but for our purposes, because we're not contesting the summary judgment ruling, I think it becomes significant in respect to the fact that we are not denying that our disclosure was deficient. So the reason it becomes relevant.
Well, I'm asking a different question. It seems like you're disputing the finding by the trial court that those opinions that you're talking about now, where he answered the expert, I don't know, I can't tell you, there isn't enough information as I read the record, from the expert, that you're saying now that it's not contradictory, that it's not new evidence. Is that not a proper factor for the trial court to consider when deciding about whether to strike that affidavit or not?
Certainly it bears on, and that's what I was trying to drive at, Judge Gurley. I mean, we do dispute that it was contradictory. We do dispute that. Now, insofar as whether it was new or not, I think our disclosure did not clearly put the defense on notice of that opinion. I mean, it's a pretty threadbare disclosure. The sin of it is that defendants negligently failed to diagnose surgical complications, or sorry, they improperly failed to diagnose surgical complications, which, on some level implies that there was a surgical complication that went undiagnosed, but it certainly doesn't directly advert to the nature of that opinion. And so we don't dispute that the disclosure was deficient. Our only position is that given it's not a total out of the blue new opinion, and that reflects well on petitioner, both for really willfulness and on the issue of prejudice. And that is how we see those issues as relevant here.
So is that your explanation for the difference between a leak and the bile issue? Does that go to willfulness, that really it was a misunderstanding and it wasn't a willful violation?
Well, from petitioner's point of view, Judge Ray, we went through this deposition. I believe that petitioner's counsel zoomed in on the testimony that I had adverted to shortly before.
Mhm.
Defense counsel, understandably, zoomed in on the other testimony. And so there's this disconnect where petitioner's counsel wasn't understanding it the way defense counsel was. And that didn't become apparent to the counsel for petitioner until the close of discovery, where there was this email exchange, which I believe appears at page 178 of the record, when defense counsel asks, and there's nothing in the record showing that defense counsel asked about this beforehand. There's kind of confusion, but it says, like, we get some more clarity about this other expert. And petitioner says, Dr. Arnott is our causation expert.
I think our questions about whether this is a sanction really come from this idea that you admit that the disclosure is insufficient.
Right.
You admit that you didn't come up with a sufficient disclosure until after the deadlines. This was all in response to a motion to strike based on a sham affidavit. The district court said, no, I don't think it's a sham.
Right.
I think it's late.
Right.
And the early one wasn't good enough. So how is it a sanction if the district court simply said, I'm not going to allow you more time to comply with an order that you already didn't comply with, and that the time has passed for meeting that deadline?
I apologize for the reason I believe it's a sanction is that petitioner was presenting evidence. It wasn't an issue of petitioner asking for more time to find a witness. It was this witness here. Here is the opinion we have. We have evidence to oppose the summary judgment motion. And in the case the district court had cited Duke, and I believe the case that Duke could rely on, which is Reeves, both of those involved, they affirmed district court denials of motions to modify. Both of them note that witnesses were unknown at the time that the motions to modify were made. So I think that's a little bit of a different issue where you have someone asking for an extension. We need more time to find a witness. These make our finding a witness timely. And where here you have a petitioner presenting evidence.
Disclosures, there were deadlines to disclose the opinions the experts would give, the information like the affidavit. There's paper disclosures. Those deadlines had passed. So how can we possibly say this was in compliance, that the affidavit, that when it was submitted, was in compliance with the scheduling order?
Justice Amaro, we do not deny that the affidavit was not in compliance with the schedule.
Okay.
Our position is simply that the reason the affidavit was excluded was that it was not in compliance with the scheduling order. That a court order that excludes evidence in response to a violation of a scheduling order is a sanction.
I guess,
On the question of the affidavit itself as rebutting, as I understand this, you just didn't have a causation expert. And, whether there's a factual dispute as to what occurred, there was just no causation. And that's what you need in a med mal. I'm not actually wondering how that's even saved by an affidavit. Assuming that judge let in that affidavit, I don't know how that saves it on summary judgment. I assume the hospital came in and said they don't have causation. Your response, you have your record to show you have someone testifying causation, scheduling orders. I just don't, not sure what this affidavit would do.
And Justice Thomas, I will agree with you that the way this was litigated below is somewhat peculiar, and I think we'll clear it up a little bit if I just explain what I understand to have been at issue during the summary judgment motion.
Okay.
The defense's motions were not premised on this bioleak did not cause petitioner to suffer injuries. I mean, it was styled a motion to exclude based on lack of causation. But the reason for the motion itself was petitioner cannot prove that her bioleak was present and diagnosable at the time that petitioner was discharged from the hospital. There was no dispute as to whether, if there was a bioleak, that bioleak caused damages. So there was no prima facie showing made in that regard. And then at the hearing itself, there's a point where counsel for defendant Presbyterian informed the district court that whether or not, and this is going to be at the transcript, page 46 to 47, that whether or not the actual bile duct injury or the cystic duct leak from which the bile leaked, whether that had occurred interoperatively was not an issue. So there was really no issue as to whether or not this injury happened during the surgery. There's no issue as to whether, if this injury happened during the surgery, it caused her damages. Or the issue is whether or not this injury was present and diagnosable the day after her surgery. And Dr. Arnott's opinions, both in the affidavit and at his depositions, the one I had alluded to previously, those were, in my view, pretty clear that she had these elevated tests.
But you can't have it both ways. You can't say on the one hand, like you're arguing now, that the deposition and the initial disclosure was sufficient, and that's what you're arguing, and then say, but we conceded it wasn't sufficient, and then say, well, we needed the second affidavit, the untimely affidavit, to establish causation. You can't have it both ways. You either have to go all the way and say the initial disclosure was insufficient and inadequate, which I think you've said in your briefing, conceded. So concede that. And then say, but we needed this second affidavit. So, I mean, I don't see that you can have it both ways.
I understand what you're saying, Justice Beal, and just to clarify, we are conceding that the disclosure was
Okay.
insufficient. We are disclosing. Our point in making these additional statements about Dr. Arnott's opinions previously goes more to the analysis of how to analyze the sanction, a prejudice and will.
Well, you're saying, and this is, you're saying it's on the one hand, the judge denied us the right to present the affidavit because it wasn't timely. Then you're saying that itself is a sanction. It seems to me all the judge is doing is enforcing its order, and that you're now in a position to have to argue that the judge abused discretion in not extending the deadline.
No, Justice Beal, I would disagree because I believe that if the district court had extended the deadline, there'd be no basis for any sanction whatsoever. The district court would not.
But you're equating enforcement of the order as a sanction.
No, Justice Beal, I'm saying that the striking of the affidavit, the order that struck the affidavit, that was.
Because it wasn't timely.
Justice Fiat. I'm seeing that, yeah. I agree. The fact you filed an affidavit doesn't make it valid. Just means you filed it late. So the judge striking an untimely order isn't necessarily a sanction.
Well, Justice Thomas, I would just say that in our view, the district court enters an order. The order says what needs to happen. The order says we need to make expert disclosures by this state. Summary judgment motion gets filed. Petitioner introduces an affidavit from an expert who has been disclosed, inadequately disclosed, but who has been disclosed. That evidence, presumptively, normally in the normal course of things, would be considered by the district court. Just normally, you present evidence in connection with summary judgment motion. The difference between considering that and not considering it is the district court's conclusion that we violated scheduling order.
But it wasn't just the scheduling order, was it? You also violated Rule 26. Court found, again, you may be disputing that finding, but didn't the trial court
No,
find that?
and Judge Gurley, again, I don't want to dispute that there were errors made here, that there were violations of both the rules and of the court's orders. I mean, petitioner is fessing up to that. There's no dispute as to that. Our position is simply that the reaction to those violations in the circumstances of this particular case was an abuse of discretion, and that the problematic issue was that the district court gave short shrift to any concept of the impact of that sanction, of the exclusion of the affidavit on this case.
Assuming it's a sanction, I'm not sure that it is, but assuming it's a sanction, why, I don't understand why the district court would have abused its discretion. They did consider the prejudice as a result of the late disclosure. They considered the reasons for the late disclosure, and they considered how close it was to the trial date. So I feel like they considered quite a bit in determining what the appropriate sanction would be.
Well, Justice Moore, as I read the district court's order, the prejudice that it found was in having to redepose witnesses, and having to refile dispositive motions, and in the resetting of the trial. And I will just point out that on the record before the district court, which witnesses would have been redeposed is not at all clear. As it appears petitioner, the only witness that would have had to be redeposed is Dr. Arnott.
Maybe one witness, maybe 10 witnesses, depending on
How
what
do you know?
happens.
Certainly, we don't dispute that. Our issue is that the court didn't hear any evidence on that point. The court simply assumed that there would have had to be redepositions done.
But your argument is really that the judge applied the wrong test.
Correct.
Because if you ask us to consider whether he applied the right test correctly, we're back in abuse of discretion land. That's pretty straightforward. That's not really what we do. So if the district court considered prejudice kind of at all, isn't it evidence that he applied the right test and there was no error as a matter of law?
Judge Ray, I would disagree with that. Based on the fact of the authority that was cited in the district court's order, as in the Butte case, which was a modification of the scheduling order case. And as well, I would point out that the district court did not consider willfulness in its order, which the case law would say if it was dismissal, really would have had to.
But let me tell you the difficulty I'm having with that argument. The plaintiff is the one that made the inadequate disclosure. The plaintiff is the one that came in with an untimely subsequent affidavit. Whether it's contradictory or all of that, we haven't talked too much about, but let's assume that it's late. And then you're saying, but the judge should have granted us an extension so that it wouldn't be late. Or consider, he'd have to allow a late filing. It was the plaintiff that forced the hand of the judge to say no mas.
And Justice,
You see what I'm saying?
I understand.
It's not that the judge was sitting there making a decision that I'm gonna throw the plaintiff's case out by denying them to do this. It was the plaintiff that forced the judge's hand to do what the judge did. Believe me, judges don't like imposing sanctions. Judges don't like punishing lawyers. They don't like punishing parties. We have lawyers brought to this court and judges on sanctions. And it's not fun, I promise you. So I can't imagine that this judge was saying, well, I'm going to do this. It was, he almost forced the judge to do what the judge did, particularly with your concessions. I know that's not really a question, it's more of a speech, but if you want to react to that, please.
I will do my best. My response to that would be, our issue is not, as I've said multiple times, we are conceding that this is problematic. And we fully concede that the district judge could have taken different action here, making a redeposition of Dr. Arnott paid for at plaintiff's expense, including making any additional depositions that had to be redone, paid for at plaintiff's expense, including attorney's fees, including conditionally granting the order to strike, and potentially including preventing plaintiff or denying the motion for extension of time that plaintiff had filed to depose these other experts. There's multiple things the district court could have done. Our argument is simply that by failing to apply the proper framework, the district court did not properly consider the implications or the degree of culpability on the part of the plaintiff before arriving at the sanction that the district court quite clearly knew. It was a combined order that granted the summary judgment.
But the judge didn't create that scenario. The plaintiff did.
Of course, which is why we can see that the plaintiff is subject to a sanction. That's we are not disputing that. It's simply that the sanction that was chosen was, too rough.
An abuse of discretion.
An abuse of discretion, yes.
That's a high standard.
It certainly is, and I
And
think
we give district court judges a lot of discretion so they can fit the thousands of cases that they have on their docket, so people get timely trials, so that we're on a level playing field where people aren't ambushed. I mean, there's so many reasons why we have scheduling orders and rules and docket management. I just feel really reluctant to go in and say, under these circumstances, the judge abused its discretion. I think it's just such a high standard.
quite rightly it is, Justice Moore, and given the docket pressures, it's totally understandable that there would be a high bar to clear. And I think, as Justice Ray alluded to, if we were just in abuse of discretion land, this would be a different case. The issue is that this court's precedents make clear that when a district court is going to dismiss a case, additional scrutiny, additional pause is required. And since what happened here, which was excluding this affidavit, it was plain as day. I mean, the orders combined, this was going to end the petitioner's case.
But the judge didn't dismiss it. That's why I asked what was the sanction. The judge did not dismiss case as a sanction. It was a consequence because without that affidavit, don't meet summary judgment.
Correct.
But the judge didn't say, no affidavit. By the way, it defends me so much, I'm pouring you out. That happens in discovery, and you've seen those, that place down the street, but it didn't seem to happen here.
Really, and I think there's a somewhat grisly metaphor, but I would ask that you bear with me. We live in a more barbaric time, and you would consider the exclusion of a witness or the striking of an affidavit as a sanction or as a penalty, criminal penalty of amputation, right? It might make sense to say amputation is a less severe penalty, death penalty. But if the penalty is amputation of the head, that is the death penalty. There's no difference. And that's the same scenario we have here. Excluding this witness would end the case. There was no debate, no question, as a matter of law. And I think that's the key point. As a matter of law, it rendered the case insufficient.
Then that goes to the issue, even under the higher standard, that goes to the issue of that this affidavit must have been so different than the deposition that it also doesn't, it's not a level playing field when they relied on the deposition, they relied on the disclosure, and then suddenly they're ambushed with a causation opinion.
And I think, Justice Moore, my response to that would be first of all, just that the testimony I've cited, the inadequate, but the disclosure that was filed previously, those things inform what the prejudice was and what the willfulness is here. And if the court had concluded that A, it needed to find willfulness, and B, that it needed to consider sanction as that's been laid out in this court's, prejudice as that's been laid out in this court's precedents regarding exclusionary sanctions, then I think we would be in a different spot if the court had made the necessary findings. But the district court's order on its face does not indicate that it applied the proper framework, and there's no mention of willfulness, my recollection, whatsoever.
Can we infer willfulness from the situation? If we believe it's a sanction, and if we're willing to tie exclusion, it's hard to call it exclusion, but the exclusion of the affidavit to dismissal and make it one big thing. If we go with you on all of that, the actual violation could be viewed as the insufficient disclosure. And there's when you acknowledged the disclosure was insufficient, when you knew what needed to be in it and you didn't put what needed to be in it, how is that what the case law refers to as accidental or inadvertent? Because that's what we're talking about when we're talking about willfulness.
Certainly, Judge Ray, and I will say, I think willfulness in many different contexts is not the most clear term in criminal law, and in the context of civil sanctions. Willfulness often gives rise to confusion. I think our argument there would be accidental is a shot of, there was no logical reason for the petitioner to not include in her affidavit, in her disclosure. It was clear that an expert needed to be disclosed. It's also, I believe, clear that Dr. Arnott was going to be petitioner's expert throughout. And if I may just briefly wrap up, I would just ask the court to look at previous cases in which this court has excluded or upheld sanctions, including lesser sanctions than the sanction in this case, such as the Lewis case. And we believe that our case clears the bar set by those cases. The proper Thank you.
Thank you, counsel. Thank you for your presentation. Hear from respondent. Antonio, 30 minutes.
You switch sides.
Feel better being in that position. Good afternoon, Chief Justice, and your honors. Larry Montano of the Halton Hart Law Firm on behalf of both of the respondents here today are Eliza Stewart with Madison Naraz. She represented Dr. Carr, trial court level. Ari Tulsa with Hinkle Shaner, who represented Presbyterian Healthcare Services at the trial court level. Chief Justice, your honors, may it please the court. In the case of Gracia versus Bittner, 1995 NMCA-064, paragraph 1, the Honorable Lynn Pickard wrote for the New Mexico Court of Appeals, in which she said that, quote, every litigated case is tried at least 3 times. There is the trial the attorneys intended to conduct, there is the trial the attorneys actually conducted, and there is the trial that after the verdict, the attorneys wished they had conducted. That is the posture that we are in here today, albeit in the context of a motion to strike followed by a motion for summary judgment. At the trial court level, in the context of Judge Allison reviewing the motion to strike and the motion for summary judgment, plaintiff's counsel was very conciliatory and recognized that what they had done was deficient. And it wasn't just in relation to their initial disclosure, it was in relation to their failure to properly respond to an interrogatory.
Well, I'm not even sure what the whole conversation about the disclosure. They were deposed, could have given the opinion in the deposition. I haven't done trial work in a while, but I'm still, let me ask you, is it commonplace in a medical malpractice where causation is a specific burden in medical malpractice through an expert, that you can revive, assuming this affidavit was timely?
Wasn't.
Well, let's assume it was. Let's say the judge let it in. Your chance to answer, your chance to move for summary judgment, they respond. Can you revive a causation claim through an affidavit in a reply? Is that common practice?
No, it's not, Chief Justice. It's not. And I think it's important to note that Judge Allison, who was a very thoughtful trial court judge, he held a hearing. It was a little bit more than an hour, but he didn't just make a decision from the seat of his pants. He didn't announce an oral decision at the hearing. He said, I want to make sure that I'm understanding this correctly. I want to go back. I want to reread the deposition excerpts. I want to make sure that I get this right. And then he issued his decision. And what I have heard today, and it is certainly the respondent's position, is that Judge Allison did not impose a sanction. He was enforcing the scheduling order. He was enforcing the rules of civil procedure. The scheduling order is, for all intents and purposes, strict liability. Did you comply with the deadline? Did you not comply with the deadline? And what the plaintiffs acknowledged at the trial court level, but they seem not to be doing here today, is that they had not complied. They had not complied with the rule because they're just.
Let me ask a question. In your view of the case, was there, because I wasn't clear in the initial argument, you believe that there was a request made to extend the deadline?
Absolutely. Judge Gurley, thank you for asking me that question. The answer is absolutely not. And in fact, Judge Allison in his decision said, no one asked me. The plaintiffs did not come and ask me to extend this deadline. And I would ask for this court, as I know you will, but to go back to the summary judgment papers, and what you're going to see is that the plaintiffs relied on Dr. Arnott's affidavit in response to that motion for summary judgment. The only time that they referenced his disclosure was in relation to paragraph 1, the first undisputed material fact that the respondents had identified in their motion for summary judgment. And thereafter, with respect to every other undisputed material fact, the plaintiffs relied on Dr. Arnott's affidavit. So this notion that, boy, this was just confusing to us because we thought that Dr. Arnott's deposition testimony was crystal clear, it certainly was not. If it was as clear, and if it did the work that the plaintiff now contends that it did, that would have been what they would have cited in their summary judgment response, but they didn't. And that is an acknowledgement. That is an implicit acknowledgement on their part that their disclosure and Dr. Arnott's deposition testimony and their response to the respondent's discovery request was not sufficient. They knew that the only way that they were going to avoid summary judgment, if at all, is by relying on Dr. Arnott's affidavit.
Mr. Montano, I agree that the district court's order reads as if it's simply enforcing the scheduling order. But when you look to Rule 16 provides for violation, what to do when there's a violation of the scheduling order, and it takes you to Rule 37, which is our sanctions rule. So even though the district court is saying, no, I'm simply not going to allow you to do extra things you weren't otherwise allowed to do. Do we have to view it as a sanction because the rule directs us to Rule 37?
Judge Ray, you do not. Because Judge Allison, both in his written decision, but also at the hearing, and it's clear to me that you have read the hearing transcript, he referred to his inherent authority to manage and control his docket. And what our appellate courts have said in myriad decisions, every one of the cases that we have cited on for this proposition, and I believe this is true for the petitioner as well, the court has recognized, putting aside the rules of civil procedure, putting aside a scheduling order, a trial court judge has the inherent authority to manage and control his or her docket.
And I think that's an interesting point, because when I was looking at Gonzalez and this willful test that we mysteriously apply when a sanction is harsher than necessary or something like that, I couldn't tell in Gonzalez whether they were relying for that test on the rule or on the inherent authority. Does that test tie itself to both?
It does not. It does not, because again, to the point of inherent authority, that goes to the issues that your honors have already identified. And I would like, if I might, to refer to something that Senior Justice Behill said. There's a suggestion that it would have been merely redeposing Dr. Arnott. Respectfully, very soon after the filing of this case, a month after the filing of this lawsuit, Presbyterian sent a discovery request to the plaintiff that tracked the language of Rule 26 Tell us who your experts are. Tell us what their opinions are. Tell us what the foundation is. Tell us what the facts that support those things are. There wasn't an objection to that in the plaintiff's discovery response. There was this pro forma statement that was eventually repeated in their initial disclosure, which was not geared toward causation. It was geared toward the standard of care. And so what we have here is a situation that from very early on in the case, the respondents had every reason to believe that this was the horse that the plaintiff was going to ride, win or lose. And so the notion that 3 months before trial, when you have formed your entire case around discovery requests, mandated disclosures under a scheduling order, deposition, and then suddenly you have a complete about face through this untimely, unauthorized affidavit, and you're going to say, let's go depose Dr. Arnott. Well, what about the respondents' experts? They didn't have an opportunity in response to a deposition where there was this testimony where they would be able to say, he's wrong. He's wrong. This cannot be. We don't have that. So I disagree with this notion that we're talking about. Just go depose one person. You've got 3 months to do it and we're all good. That's not the case.
Can I ask a question about your view of the affidavit, the testimony contained in it, if it was new and or contradictory to the deposition testimony?
Judge Gurley, it was absolutely contradictory to his deposition testimony. Judge Allison said as much.
That's why I asked the question of the petitioner about whether that was a quibble with that finding or not.
Correct. And in response to your question, Judge Gurley, Judge Allison and I agree wholeheartedly with what Judge Ray noted in the contours of the hearing. He talked about sham affidavits and he says, I'm not prepared to go there. I'm not going to go and say, and as the Chief Justice has rightly noted, we all know the difference. A dog knows the difference between being stepped on and kicked, right? There's a difference. You can sometimes have the same overall effect, but one thing is inadvertent and one thing is not. And in this case, what the judge said is, look, I'm not here to make windows into men's souls. I'm here to tell you that you had deadlines to do certain things and you didn't do them, and I'm going to enforce my scheduling order. We are 3 months away from trial. This is going to completely alter the complexion of this case, and both as a matter of not satisfying your obligations, plaintiff, and also prejudicing the defendants, not allowed that.
So let's assume that we think it is a sanction. Why did the district court not abuse its discretion if it is a sanction? And then what standard do you think we should apply?
Thank you for the question, Justice Zamora. What this court has stated in decision after decision is that the exclusion of witness testimony, whether it's the witness's testimony completely or not, is still subject to an abuse of discretion. And so it is true that if it is a sanction, then what this court has admonished our trial courts to do is scrutinize it a little bit more closely. But you're still operating under the context of an abuse of discretion standard. But I want to make it abundantly clear here that the respondent's position is that Judge Allison did not grant summary judgment to the respondents as a sanction. What he did is he excluded an untimely affidavit, and he did it pursuant to his scheduling order. And it's true that in the context of a medical malpractice action, that if you don't have expert medical testimony on standard of care and on causation, that the consequence of that is going to be that you're going to lose your case. But that's a very different matter than to say to somebody, I'm not going to entertain this issue. What you did is so wrong, you're done. I'm sanctioning you, you're done. And we can talk about the new opinions and the contradictory aspects of them, but fundamentally, that's not what Judge Allison was thinking. What he was thinking, and his thinking is very clear because we have the transcript of the hearing, and we have an 8-page opinion from him in which he is explaining his thought process. And his thought process is, I need to be able to enforce my scheduling orders. And if that means that somebody loses a case, that's one thing. And that's ultimately what he did. But to say that he dismissed the plaintiff's lawsuit, or that he granted the respondent's motion for summary judgment as a sanction is not true.
But at least in Allred, at the very least, there's this suggestion that you can tie a distinction or a sanction less than dismissal all the way through to dismissal under some circumstances, and that was not this court. And there's also Lemire. And I'm interested in your thoughts on both cases, because those are the two that to me suggest this tie exists.
Your Honor, I do have a note on that. Could you tell me specifically what it is that you're?
Yeah, so in Allred, Exeter Allred v. Board of Regents, we have the Court of Appeals declining to differentiate between outright summary judgment grant and a conditional order stating disclosure of certain information about a CT scan needed to be precluded. They just sort of breeze right by it. There's not a lot of discussion about it, but there does seem to be a suggestion that the tie that we're talking about here, a lesser sanction that leads directly to dismissal, was contemplated. And then Lemire is the criminal case that deals with exclusion of witnesses and the test that you need to apply before in a criminal case you can exclude witnesses.
Yes, and let me begin with Allred, because I too had spent some time looking at that case. And what I would commend to the court is that paragraph 47, the New Mexico Court of Appeals, this is 2017 NMCA-019, at paragraph 47, it ruled that, quote, a failure to make, and this is the implication, the disclosure required under Rule 26, that's the end of my interpolation, is sufficient ground to exclude expert witness testimony. That was the foundation for the decision in Allred, is if you don't make this disclosure, then that is going to be a basis for it. And ultimately there, yes, there was the consequence that you noted, Judge Ray, but that is ultimately the rule that the Court of Appeals relied on. And then in the criminal context, I think that that is obviously quite important, as your honors know better than anyone. When you talk about the criminal context and you're talking about fundamental error, this court and the Court of Appeals and our trial courts are obligated as an independent matter outside of the civil context, as an independent matter to assure themselves that the criminal defendant has been given the due process to which he or she is entitled to. And so in that instance, if the defense counsel is deficient in some respect, whether it's intentional, it's inadvertent, it does not matter. Because as a matter of fundamental error, the courts are obligated to ensure that that person's due process rights are protected. I do want to spend some additional time just talking about what I think is really at issue here. The district court, as I have said, declined to extend the expert disclosure deadline contained in its scheduling order. And I want to just be very clear here that that is found at record proper 482 and 483, and these are direct quotes from Judge Allison. Number one, plaintiff did not seek leave to supplement her expert opinion. And I ask this court, when at the trial court level, plaintiff's counsel says to Judge Allison, we have no excuse. We flubbed up. We made a mistake. That's our fault. How can you say that on the one hand? And then you supply this untimely affidavit, but you don't go to the court and say, Your Honor, in retrospect, we thought that Dr. Arnott was entirely clear in his deposition testimony. We thought maybe not our disclosure, but we thought that our interrogatory answer was sufficient. And so we apologize, but here's a motion in which we were asking for you to amend the scheduling order. If the judge had denied that motion, would we be applying an abuse of discretion standard? Would we be applying this heightened standard that the plaintiff alludes to but cites no case to support it? Why should the plaintiff be rewarded for not even seeking leave of court, but instead, as Senior Justice V. Hill noted, essentially putting Judge Allison in the position of having to say what he said? At least under the scenario I described, where a party comes forward and says, our mistake, please give us an opportunity to rectify this error, and here's why we think you should do it, and here's why there isn't going to be prejudice to the defendant, and there you go. With Judge Allison, who knows what he would have done under that circumstance? But that's not what happened. Instead, after the close of discovery, after the close of dispositive motions, there is this affidavit that is thrown on his desk and said, you should let us do this.
My understanding of plaintiff's position on that is that they really didn't understand the disconnect between the testimony and their view of their case until they got the summary judgment motion. And that sort of seems to be what was underlying Judge Allison's, decision not to find a sham affidavit. Plaintiff came to the hearing and explained where they were coming from on that, that they understood the testimony in this way, and it wasn't until much later that they understood the defendant had understood it in quite a different way. At some level, it does just seem like a misunderstanding.
Judge Ray, I think Judge Allison was being a gentleman. I think he was also recognizing he didn't have to go there. And so he did what he felt was appropriate under the circumstances, this notion that he didn't grapple with the consequences of his decision, that he didn't recognize the impact that this would have on this case, is simply not borne out by his observations at the hearing, by his 8-page opinion that we all have an opportunity to read today. And so, agreed, Your Honor, he did not attempt to even say that you did something that was completely fraudulent. He didn't do that, but he didn't have to do that. And frankly, I think what you're being asked to do here in this case is essentially to require our trial court judges, every single time they're going to make a decision, not to take something at face value and to ascertain, did somebody comply with the rules of civil procedure? Did somebody comply with my scheduling order? Did they or did they not? But let me think also 2 steps ahead, or even 1 step ahead, and say, but if I do this, then that. And respectfully, that's not what our rules say. That's not what our cases say.
It's not, but he knew. I mean, the judge said at the hearing, he made very clear with plaintiff, if I do this, this is your only evidence of causation. I mean, this didn't surprise him.
Correct. Oh, and I think that's why he took it especially serious, is a recognition that in a medical malpractice case, and these are very capable lawyers, and know full well that if you don't have an expert that can testify competently about standard of care and causation, you're done. But I dare say that is yet another reason to hold the plaintiff's feet to the fire, just like a defendant's feet would be held to the fire. In a context like this, where we're not talking about novel legal issues, we're talking about settled principles of law. A plaintiff knows that they need this testimony in order to succeed in their case. And so they are the ones who have control over who they engage as an expert. They have an opportunity to vet that expert, to ensure that that person, and again, not casting aspersions, this is what all parties do, is in retaining an expert to believe that that person is going to say something that is helpful to your case. So they are the masters of their own destiny in that regard.
I guess I raised that notion that Judge Allison knew, because I was also worried. What kind of standard are we creating where district court judges would have to guess at whether the result would someday be dismissal, the result of a sanction, because it's not always as tied together as it is in this case. And so you might make a ruling that ended up resulting in dismissal sometime down the road. But in a case like this, where the court itself tied its ruling to dismissal, doesn't the case get stronger that you need to treat it like a dismissal sanction rather than an exclusion sanction?
I think it's quite the opposite. I think that it's in that scenario where the parties' obligations are clearer in terms of what they must do in order to prevail on their case. And what this court is being called upon to do is to announce a rule. I started by noting Judge Pickard's decision. All of us, I think, are a bit amused by it from time to time. But the reality is this: go back and take a look at those summary judgment papers. When did the plaintiff ever say to Judge Allison, Your Honor, you're about to enter a sanction that is tantamount to the death penalty, and you need to apply this higher standard, and you need to determine that we've done something intentionally incorrect in order to make the decision that you've made? That wasn't the posture in which this case was decided.
I still can't get past Rule 26, scheduling order or not. Isn't that notice to everybody? Doesn't that set out clearly what both parties' obligations are? Disclosures are important.
It does, Judge Gurley.
And what would you expect as a litigant then if you don't disclose something?
That you're going to lose your case. You're going to lose your case. And I've too thought of various scenarios, Judge Ray, just to try and ascertain, the basis for Judge Allison's decisions and whether it should be vulnerable on appeal. And I thought of different scenarios, and the reality is that district court judges make decisions every single day in the heat of trial, in the heat of pretrial proceedings. I think it was Justice Zamora who noted the hundreds of cases that trial court judges have responsibility for. And I think in many instances, not just a few hundred, but we're talking many hundreds of cases. And if they don't have the ability to enforce their scheduling orders, no matter what the consequence is, then I think they are being held to too high a standard. But it also would be directly contrary to the settled principles of law that both sides have articulated in their papers. I wasn't being facetious when I said that it's an abuse of discretion standard that applies in every iteration that we can think of in this context. And that applies to the amendment to scheduling orders, which was the Buke case. It relates to the choice of discovery sanction that was articulated in Lewis versus Sampson. We have the Allred case that I mentioned to you earlier, and we all know what an abuse of discretion standard is. Did the decision maker do something that is illogical? Did the decision maker do something that is not supported by the record? That's not the situation that we are confronted.
So assuming that we think this is a sanction and assuming we believe the willful standard should apply, you in your briefing still stated your client should bail.
Yes.
Can you explain why?
Yes, Justice Moore, the reason is that willfulness is not tantamount to intentional wrongdoing. The standard is gross indifference. It can be as low as simply not doing, something that you need to do. And in this circumstance, and that's why I began by saying that this is not just a matter of, boy, your initial disclosure was so deficient, you're done. If you look at Judge Allison's decision, had he stopped there, then I think you could say, well, this is just, him saying it's a sanction, your initial disclosure was deficient. But he didn't do that. He went on to evaluate the deposition testimony. And he went on from there. And there were, as we said in our brief, and we weren't saying it just to try and be controversial or to grab your attention, but it's the truth. There were 3 or 4 opportunities to have averted this situation. And it could have been done in the initial disclosure. It could have been done in an interrogatory answer. It could have been done at a deposition. It could have been done prior to the filing of summary judgment. So, thank you. If there are no other questions, I'll complete my presentation.
Thank you, Mr. Montano.
Thank you.
In the matter of S-1-SC-40434.
Did we give him the 30 in the first?
We'll give you 5 minutes on rebuttal. You have 30, and I can cut off Mr. Montano. But you asked for 30, we gave you 30. All right, we'll give you 5 minutes on rebuttal.
I just wanted to respond to a few points that Mr. McCartney had raised. One of those is just the point about the plaintiff trying to change the position to argue that there was compliance with the district court's order. We are not arguing that there was. The disclosure does not comply with what Rule 26 required plaintiff to disclose. The issue that petitioner has is just that the consequences, consequence that the district court imposed as a result of that warrant abuse of discretion. So the petitioner does not contend that they should get off scot-free, and that's the end of the story.
What is your best case, to Judge Ray's question, that there's an obligation for a trial court to look down the road like that?
I would say
It's a direct sanction, but look down the road as a consequence. What is your best case for that?
I would say, Justice Thompson, that is the Allred case. There was actually 2 Allred cases in this case. One of them is 2017. One of them is 1998, if I believe correctly. The 1998 Allred case would be petitioner's best case, directly on point. A number of unpublished Court of Appeals opinions, which of course I understand the court for not relying on those. I would also know that Allred relies on a federal case, I believe, from the Ninth Circuit, Sumitomo. It was a well-established rule for a long period of time in the Ninth Circuit that situations like this were subject to a heightened standard. A number of federal courts have also reached that conclusion. I would note in that respect that federal case law is not all that helpful on this issue because it tends to go in different directions. But the underlying thrust that consequences of a sanction as a result of a violation.
So again, going back, we have a trial court judge over here, but in a 2-week, 3-week trial, I got to tell you, I wouldn't know what expert is tested. I tried to remember the names of doctors. And now I'm supposed to be like, I'm putting the plaintiff's case together. I'm going to rule on this. And now I'm pouring them out on causation. It just seems a huge burden for a trial court. You'd literally have to know the case. You'd have to know the plaintiff's case. And in multiple counts of alleged malpractice, medical malpractice, you know, was it the nurse? Was it the doctor? Was it the, was it the bile duct? That just seems like an enormous burden.
And I understand, Justice Thompson, I did want to make that point as well, that our argument is based on what is known to the trial court when it makes its decision.
And you're right, in the record, and Judge Ray pointed this out, this was known.
Correct, Justice Thompson. And so I don't think that, if this has happened, then 2 months down the line, it turns out, oh, actually looking back, the disclosure shouldn't have been struck.
He knew it.
Correct.
He knew it.
Yes.
But he didn't create the situation.
No, petitioner created the situation with the.
And there was no motion to extend the deadline.
Justice Beal, I'd revert back to my earlier response that if a motion to extend the deadline had been granted, there would have been no untimely disclosure.
There was no motion filed to grant.
Correct, which results in this affidavit being untimely.
Again, the creation of who? The plaintiff, not the judge.
Correct.
And you're saying the judge has an obligation to look down the road to consequences that he or she didn't create. It's created by the party here, and then the party before the court doesn't even ask for relief.
Justice Beal, I think my response would be that.
And I need to, I apologize for raising my voice. I really do. I'm working on it, and
Made it till the end.
so anyway, I apologize.
I hope.
You're in good shape.
Justice Beal, I just wanted to, I would like to just briefly respond to the argument regarding inherent authority that Mr. Tanya. The purpose of Rule 16 and the sanctions provisions of Rule 16 were to address violations of the scheduling order, which is undisputed that there was a violation in this case. In other contexts, both this court and I believe the Supreme Court have noted that when there's a rule that's on point, that rule is ordinarily assumed to displace inherent authority because the reason for the rule is to govern that precise situation. And so where you have a rule like Rule 16, scheduling order sanction rule that refers back to Rule 37, the purpose of that rule was to address non-compliance with the scheduling order, as is undisputed there wasn't. There are no further questions, I think.
Thank you, Mr. Johnson. Thank you for your presentation. I want to thank the petitioner respondent for their presentation of papers in the matter of S-1-SC-40434. This matter is deemed submitted. This court will be in recess until October 27, 2025 at 9 a.m.
Adjourn the court, please.
So you know.